The court will come to order. So said Judge John Ralston. It was Friday, July 10th, 1925. It was just a little more than 2 months after George Rapelier hatched his plan in Robinson's drugstore. The trial began. It was hot in Dayton, Tennessee. If you are a fan of the Johnny Carson Tonight Show, you know what comes next. You're supposed to say, "How hot was it?" All I can tell you is the funniest joke I can make is to say it was so hot that the lawyers actually took off their suit jackets in the courtroom. It was really hot. It was really hot in Dayton, Tennessee. While preparing this lecture a while ago, I was in the midst of a podcast presentation by the Yale law professor and historian Akhil Amar on the history of the Bill of Rights. If you are unfamiliar with the work of Akhil Reed Amar and you're interested in constitutional and legal history, you will thoroughly enjoy his books and his teachings that you get to hear on various podcasts, such as lectures from the New York Historical Society and the podcast We the People, put on by Professor Jeffrey Rosen, the head of the National Constitution Center. These are gems, and some of us regard Akhil Amar as a national treasure. So Professor Amar in this podcast was addressing the question of why the original Constitution does not include a Bill of Rights, right? First Amendment, all that stuff wasn't a part of the original Constitution. And Professor Amar says that part of the explanation was it was really hot in Philadelphia, and the delegates to the Constitutional Convention, who had been there from May 25th to September 17th, 1787, they were tired and they were hot. No kidding. Do not underestimate the effect of heat on the human mind and spirit, and thus on the administration of justice. It was hot in the courtroom in Dayton. Let's get into the courtroom. We're told that it had a capacity of 400 people, and yet 700 people were stuffed inside that courtroom. 700 people to watch a trial? When was the last time that's happened? Had it ever happened, I don't know. I can tell you what else had never happened. As I mentioned quickly last week, radio station WGN of Chicago broadcast the daily court proceedings, and we're told it cost them $1,000 a day for the telephone line. Would you like to hear a recording of what WGN broadcast? Yes, so would I. But there is no such thing. The Chattanooga Times was publishing the full transcript of the trial each day. It was remarkable. So let's get the trial started. How did it start? Yes, the judge said the court will come to order. What do you think the judge said next? Call your first witness. Counsel, I'll hear opening statements. No. The judge's next words were, Reverend Cartwright will open court with a prayer. O God, our divine Father, we recognize thee as the supreme ruler of the universe, in whose hands are the lives and destinies of all men and of all the world. We approach unto thy province this morning. Thy province? I thought we were in the court's province. But we approach thy province this morning, and we trust with that degree of reverence that is due unto thy supreme majesty, and with the consciousness of the fact that every good and every perfect gift comes down from thee, Father of lights. Reverend Cartwright went on for about 5 or 6 minutes. I know this because what I've done is I take the trial transcript, I take a page, I read it, so I have some idea of how long these things took. He goes on for 5 or 6 minutes. I won't take you through his entire text, but some of it's too good to let it go by. We beseech thee, our heavenly Father, that thou wilt grant unto every individual that share of wisdom that will enable them to go out from this session of the court with the consciousness of having, under God and grace, done the very best thing possible and the wisest thing possible. To this end we pray that the power and the presence of the Holy Spirit may be with the jury and with the accused and with all the attorneys interested in this case. Then he continued, hear us in our prayers, our Father, this morning for the cause of truth and righteousness throughout the length and breadth of the earth. And, O God, grant that the President of the United States, down to the most insignificant officer thereof, that the affairs of church and state may be so administered that God may beget unto himself the greatest degree of honor and glory. God may beget unto himself. I'm not even sure what that means, but holy cow. After that opening, I'm surprised they didn't just take Scopes out and shoot him. So now that the opening prayer was out of the way, time to actually start the trial, right? Not so fast. Scopes had been indicted in May. Remember, there was that special session of the grand jury because they didn't want to wait until the August session of the grand jury to indict Scopes because some George Rapelier in some other town might come along and steal their idea and their thunder. But now we're told there was a question about the legality of that indictment, whether it had expired. So what do? Well, you could wait until the next session of the grand jury to be impaneled and then get another indictment. No way, no way. All the hotel rooms had been booked, the press was at hand, the courtroom was packed. This show must go on. So Judge Ralston impaneled a new grand jury right then and there. And he tells this new grand jury that Scopes had been indicted on May 25th, that there's some uncertainty about whether that indictment was valid, so the judge had determined to convene this grand jury for the purpose of reinvestigating these charges. I'm not sure there's going to be a whole lot of investigating going on here. I mean, you tell the second investigator that a first investigator already saw fit to issue an indictment. This is a joke. So the judge then reads to this grand jury the charge that he read to the first grand jury. Here's what it said. The law makes it unlawful to teach any theory that denies the story of divine creation of man as taught in the Bible, and to teach instead that man descended from a lower order of animals. You might recognize that language from the statute, the Butler Act. But Judge Ralston wasn't finished. Having read the indictment, what do you think Judge Ralston then read to the jury? Listen to the judge. Since the act involved in this investigation provides that it shall be unlawful to teach any theory that denies the divine creation of man as taught in the Bible, it is proper that I call your attention to the account of man's creation as taught in the Bible. That's right. Judge Ralston then read the entire first chapter of Genesis, all 36 verses. No, despite popular demand, I'm not going to do so for you. The judge then says, this statute involves only a misdemeanor, not a felony, but, quote, I regard a violation of this statute as a high misdemeanor because of the evil example of the teacher disregarding constituted authority in the very presence of the undeveloped mind whose thought and morals he directs and guides. Evil example? This guy was out playing tennis, right? They drag him into Robinson's drugstore. He says he probably didn't teach evolution. They said, "Aw, can't you just say that you did?" So he says, okay, and now he's an evil example. The judge said he disregarded constituted authority. Now, whether it was Scopes or the actual biology teacher, if they taught anything, it came from the textbook that the state had been using for 16 years, the textbook that Doc Robinson was selling from his drugstore. What's going on here? Of course, this was a show trial, and everybody knew it. What's going on here is we have a judge who's going to run for re-election in the next year. He needed this show to showcase himself. So there's much that is interesting and, yes, entertaining about this opening exercise, like, what's the judge doing reading from the Bible? Leave that aside. We could also ask a more, I suppose, mundane question. What Bible was he reading from? We're going to get to that in a future lecture. But for now, I want to look at a different question. And to do so, I'm going to borrow liberally, that's right, steal, from a good friend of mine, Dr. Joel Hoffman, and from Joel's book, The Bible Doesn't Say That. Joel is a PhD linguist with a special interest in the problems and myths of translation from Hebrew in religious texts, particularly the Bible. So for fun, every once in a while, Joel and I get on the phone and we talk about interesting issues of translation and biblical interpretation or rules of evidence. We do this just for fun. Part of the fun for me is I've known Joel since he was 4 years old. So Joel writes that we all know that the Bible says God created the world in 6 days. I'm no biblical scholar, I'm just reporting here, okay? But right, God created the world in 6 days, and it goes something like this. The heavens and the earth were created the first day, along with light and darkness, the sky and the water on the second, the continents, land, and plants on the third day, and so on, and humans on the sixth day. We also know the Bible story about Eve being created from Adam's rib. I know this is beginning to sound like a retrospective of the work of Spencer Tracy. So what about Adam's rib? Follow along carefully. The story of Adam's rib comes from Genesis chapter 2, verses 21 and 22. But by Genesis 2, Adam and Eve had already been created. God created male and female in his image in Genesis 1, verse 27. More confusion. Genesis 2, verse 2 says, God finished all the work that he had done. The woman created from Adam's rib had been created several verses earlier. What's going on here? More confusion, right? In Genesis 1, verse 27, male and female people had already been created. It says God completed the work of creation in Genesis 2, verse 2. But Genesis 2, verse 18, the sole man of the earth was still alone, which is why God had to form every animal in Genesis 2, verse 19. In that context, a single male human with only animals around that God created woman from man's rib. So to recap, 6 days to create the world, animals, then man and woman, then God rests. After God rests, man is alone with no women and no animals, so God creates animals, right? Man's lonely, so God creates woman. Huh? If God rested after creating animals, then man, then woman, how could man be alone with no women and animals after God rested? How can this be explained? The explanation, as it were, Joel says, is, some say there are two separate creation stories, right? This may be familiar to many of you, but not to those of us who are not such Bible scholars. First creation story is more familiar. All right, God creates in 6 days, rests on the seventh day after creating everything. The second story, man comes first, then animals, then Eve from Adam's rib. In the New Revised Standard Version of the Bible, it actually captions the first one, 6 days of creation and the Sabbath, and the second version, another account of the creation. Another account, suggesting it's the same creation, only differences in the telling. So let's see what Dr. Hoffman says. He says, it doesn't take too careful a reading to suggest that there are two separate stories, not two accounts of the same story. The differences, he said, are too striking. There's no vegetation on the earth in Genesis 2, verse 5, even though the plants were created in Genesis 1, verses 11 and 12. Adam is specifically alone without any animals in Genesis 2, verse 18, even though Genesis 1 is equally clear that the animals were all created before Adam. Now, Joel specifically notes in his book, presumably for my benefit, this very point was raised by the defense in this 1925 Scopes monkey trial. He says the defense noted that there are two accounts in Genesis of the creation of man, right? Accounts being now a somewhat loaded term, implying it's the same creation, just two different versions, and Joel himself takes issue with that. But the defense noted two different accounts. They are not identical and at points differ widely. It would be difficult to say which is the teaching of the Bible. Judge Ralston skipped that little tidbit in reading the jury the purported biblical story of creation. So now the grand jury has heard the text of the Butler Act and the proposed indictment and heard a reading of one part of Genesis that may or may not be pertinent. What else would the grand jury need to know? Well, Scopes supposedly taught something in violation of the Butler Act. How is the grand jury supposed to investigate and know what Scopes taught? The prosecutors, what the hell? Tell you, the best laid plans. The prosecutors wanted 3 students of Scopes to say that he had taught them evolution. These are 14-year-old boys. They didn't want to get their teacher into any trouble. So these 3 14-year-old students of Scopes, they take off into the woods. Somebody had to go find them. Who do you think went to find the students? That's right. No, very good. You're on to, not the judge, our hero, John Scopes. He goes out and he finds the 3 students and he persuades them to testify to ensure that he would be indicted. Now, you remember I read you last week Scopes' account of this, where he's preparing these students for their testimony in the back of Stumpy Reed's cab. And I think it's fitting that Scopes is the one who went out and found the students, because after all, it was Scopes who went out and found the deputy who served him with the warrant for his own arrest. Does this sound like any case you've ever heard of? So Scopes succeeds in corralling his students. They testify before the grand jury. 11 o'clock, the grand jury did what everybody, the prosecutors, the defense, the judge, the press, the town of Dayton, what everybody needed it to do. They indicted or re-indicted Scopes. Whew. All right. Now the case can go forward. It goes forward with the thing that we generally do at the beginning of a jury trial. They have to pick a jury. So we start in with picking the jury, right? No, by now you understand, no, nothing goes in the proper sequence here. Clarence Darrow stands up and he raises a question that will run throughout the trial, and it's an important question. He says, the defense has assembled a team of expert scientists who are going to testify as experts about evolution. Now, they're here from out of town. They've come a long way. They're not getting paid. Darrow would like to have an idea when they will get to testify. Now, some of you may appreciate, in a real trial, this would have all been sorted out well before everybody shows up in a courtroom, right? I mean, judges and lawyers know how to do these things. This is no ordinary trial. So now everybody's sitting there, 700 people in the courtroom, and we're talking about when are the experts going to get to testify. So the lawyers talk among themselves, and then Tom Stewart, arguing on behalf of the state of Tennessee, says, look, we're opposed to these witnesses anyway. They're not competent witnesses. They don't have anything to say that would be relevant to the case. We're going to hear a lot more about that later. So he says, we'll agree to take up this matter of the witnesses. We'll take it up out of order. We're not going to wait until they get called at trial. We'll address it after we come back on Monday, as opposed to waiting for them to be called. We'll get back to that issue. Now we get on to picking a jury. Let me just say a quick word about how this is done. Some of this may be familiar to you, but of course it's done differently in different places. And the questioning of prospective jurors is what's known as voir dire, right? In the French means to see, to speak, from the original Latin, verum dicere, to speak the truth. This is all about the juror's oath. In many courts, the judge questions prospective jurors. Why? Because when judges do it, it goes faster, and judges know lawyers are engaged in a little bit of show business when they are questioning prospective jurors. Lawyers like to do the voir dire. Why? Because it gives you a moment of connection with somebody who may wind up on the jury. You get to look the prospective juror in his or her eyes, and with all of the warmth and charm that you can muster, you're able to say, Mr. Smith, I assume there's no reason that you could not render a fair and impartial verdict in this case. Am I right? Now, every once in a while, Mr. Smith says, no, actually, I hate all bankers, landlords, tenants, minorities, whatever. But, if so, that person's going to be struck from the jury. But really, often and there are a lot of legitimate questions to ask prospective jurors, but that business about can you render a fair and impartial verdict, that's a question where the question and the answer are irrelevant. The lawyer may have other grounds to strike a juror, but the lawyer wants to do this because if this person winds up on the jury, you figure you had at least one moment of one-to-one contact where you try to burn your way into that person's soul. This is what trial lawyers are thinking about. Now, as they're picking a jury, keep in mind the incongruity that runs throughout the trial. The ACLU wanted to test the constitutionality of the law. The chance of the trial judge ruling it unconstitutional was pretty slim, but that wouldn't have mattered anyway, because whoever lost at trial, either the state of Tennessee or Scopes, whoever lost was going to appeal. This was going to wind up in an appellate court, maybe the U.S. Supreme Court. I mean, you'll hear commentary throughout. You already heard some last week about how that's where the Scopes team wanted to be anyway. So if all of that is true, why did they approach jury selection, and why did they fight during the entire trial as if they wanted to win? I think there are a couple of reasons. First, if you're going to be arguing in an appellate court, on balance, there are all kinds of advantages to having won in the trial court. Won't go into the technical stuff, but if you appeal, there are burdens that the law imposes on the losing side. The evidence may come in at the trial in a way that bolsters the legal arguments that you need to make in the appeal. Put it simply, winning generally beats losing at every stage. So the defense probably figured they could have their cake and eat it too. Try to win a trial, and then don't worry, the state will appeal anyway, so we're going to get our day in the appellate court as well. That's one explanation why they fought to win. There's another reason, I think, that they fought that way. Clarence Darrow, Arthur Garfield Hayes, Dudley Field Malone, John Neal, these were real lawyers with real intense emotions on these issues. And they were lawyers accustomed to pursuing victory. I mean, in their minds, they might have understood that most, if not all, of what went on in the courtroom would have little bearing on the ultimate legal outcome, but they would have been congenitally incapable of just laying down their swords. And of course, there was the element of them playing to the court of public opinion. So when we're picking a jury, to do this in this court, They were picking names out of a hat to create a pool from which the actual jurors would then be selected. So Judge Ralston decided to select a townsman for the high honor of picking the names out of the hat. Who does he bestow this honor on? A distinguished Dayton citizen named Thomas Jefferson Brewer. From the name alone, you know this is a person reared for greatness. So let's meet Thomas Jefferson Brewer. Still not sure how the slide went ahead without my clicking it. That's right, 4-year-old Tommy Brewer, who no doubt was forever grateful that his parents sent him over to the courthouse with that hairdo. He lived across the street from the courthouse. His parents were asked if he could come over. He did. He sat on Judge Ralston's bench. He drew 20 names out of a hat, and the judge gave him $1. The judge had a child draw up the names? I mean, is this a trial or a carnival? Well, there was an election coming, I told you. The first prospective juror, a man named W.F. Roberson. I just want to give you a little flavor of how this went. The judge, Mr. Roberson, have you formed or expressed an opinion as to the guilt or innocence of this defendant, John T. Scopes? Roberson, well, to some extent, Judge. Judge, well, what do you base that opinion on, Mr. Roberson? Roberson, rumor. Judge, from some witness, information from some witness, some of them who profess to know? Roberson, no, sir. Judge, general rumor? Roberson, yes, sir. Judge, I think he's a competent juror. The state says, we'll take him. Clarence Darrow, are you satisfied that you could try it with perfect fairness to both sides? Roberson, yes, sir, I think I could. Darrow says, he's fine. The third prospective juror, a gentleman named Jim Riley. We're told he's wearing a white shirt. He's got dark blue glasses. Now here we get our first glimpse as Darrow as the trial lawyer's trial lawyer. He asks Mr. Riley, Darrow asks Mr. Riley, did you ever hear Mr. Bryan speak about evolution? Riley, no, sir. Darrow, ever read anything he said about it? Riley, no, sir. I can't read. Darrow, well, you are fortunate. I think Darrow's playing to several audiences here, maybe to Mr. Riley to see if he can get a laugh, maybe to the spectators. Darrow's trying to show he's a real guy. Darrow says to him, well, is it your dark blue glasses? Riley, no, I am. This process goes on for a while. We had a preacher who preached at 4 different churches who tried to get on the jury, but he lost out when he admitted to Darrow that he had an opinion on evolution. He said, I preached against it, of course. Juror after juror, Darrow asked what they do for a living. Do they have any thoughts about evolution? Would they be capable of being fair and impartial? Right? This is all show business. Before the end of the day, we've got a jury. 9 farmers. 5 of them had lived in Ray County since birth. In addition to the Mr. Riley who couldn't read, 3 of them testified they had read no books other than the Bible. The author, Ray Ginger, commented, these were men who had compensated for the narrowness of their own experience by ignoring the experience of others. 6 Baptists, 4 Methodists, 1 disciple of Christ, 1 who did not belong to a church. Scopes said he knew all the jurors by sight, if not by name, and he said, it's safe to assume that I had an excellent chance of being convicted. There'd been discussion about whether the trial would resume the next day on Saturday, but Judge Ralston said, see you Monday morning, and with that, the first day of the trial was now over. What happened between Friday close of business and Monday morning at 9 o'clock? Plenty. Friday night, the defense lawyers began preparing their argument to have their scientists testify. Remember, Tom Stewart for the state of Tennessee had said, let's argue this Monday morning. So on Saturday, Stewart goes out to the mansion. This was what they called the large house on the edge of Dayton where the defense team had holed up. Stewart goes to the mansion where the defense lawyers were huddled. John Neal and Dudley Field Malone are there. Clarence Darrow is not. Tom Stewart says, I've changed my mind. The matter should be addressed when the time comes, not Monday morning in advance. He was worried that technically this would be getting the judge to make a ruling before it was necessary. Maybe it would be subject to appeal on that point alone. He didn't want to create that kind of issue. Well, if you're a lawyer receiving a proposal from the other side, of course, you're trying to figure out how is this good for him, how is this bad for us. But in any event, Neal and Malone agree. We'll deal with it when the time comes. Stewart goes back to town. Clarence Darrow shows up at the mansion and says, what the hell did you guys agree to? No way. I want to go through with the original plan. Otherwise, we have a couple of scientists sitting around here for what could be a week or two. So John Neal goes back to Dayton to tell Tom Stewart that the defense had changed its mind. Ultimately, the defense decided to wait until the scientists were to testify. But that decision had ramifications for what became the most famous scene at the trial, but that's for lecture number 4. So what's going on this Saturday? The defense lawyers are preparing their argument about admitting science expert testimony. Most of that was going to be about science, but seated among the lawyers was Rabbi Herman Rosenwasser of San Francisco. I have to ask you to indulge me a brief personal word. Involvement of clergy on the defense side of the case, of course, is of interest, and I'm going to refer to a few of the clergy at various times, but I suppose I should note for you that I am Jewish. Back in my youth, I distinctly recall the contemporary Jewish philosopher Mel Brooks saying to Johnny Carson that he was confused by the reference to him, Brooks, being of the Hebraic persuasion, because Brooks said he did not recall being asked. In any event, I'm of the Hebraic persuasion. When I set out on this exploration of the Scopes trial, a piece of me wondered, were there any Jews involved? I was fascinated by the image of Dayton, Tennessee, and Jews. Now, Rosenwasser was not the only rabbi connected to the trial, but he played, or attempted to play, a unique role. So here goes a little sidebar discussion. Rabbi Herman Rosenwasser, and we are led to believe that, to the extent you can see any of these PowerPoints, that's Rabbi Rosenwasser, and it may not be clear to you, but this is a Hebrew text that he has up on that board. Rabbi Herman Rosenwasser was born in Hungary around 1879. We know he was 46 years old at the time of the Scopes trial. I haven't found anything to explain his coming to the U.S. We know he received a Master of Arts degree from the Western Reserve University. He was ordained as a rabbi by the Hebrew Union College in Cincinnati in 1908. HUC is the rabbinic seminary of the Reform Jewish movement. But I wonder, who was this guy? I mean, it's 1925. He goes from San Francisco to Dayton, Tennessee, uninvited. He's trying to play his way onto the team. I was intrigued. So San Francisco, I appealed to a friend of mine, Doug Kahn, who was a Reform rabbi with long roots in San Francisco. He steered me to a friend of his, a guy named Fred Rosenbaum, whom I don't know, but Rosenbaum was something of an amateur historian of the San Francisco Jewish community. So I wrote to Rosenbaum. My first question was very carefully worded. And in response to my carefully worded question, Rosenbaum said, no, Rosenwasser was not a nutcase. Okay? He was a respected rabbi of a major congregation, one of the 4 leading congregations in the city from the 1860s through the 1920s. It lost its synagogue during the Depression. It dissolved in 1940. So very few people today know anything about this. Rosenwasser had ambitious plans for his synagogue, but ultimately they made the mistake of choosing one of their congregants to lead the fundraising drive, who was a notorious crook, who wound up in San Quentin. So Rosenwasser had big dreams that didn't materialize. For our purposes, Rabbi Rosenwasser was a student of language. And we're told he spoke not only English, but German, Yiddish, Hungarian, and Hebrew, and he could read or translate Latin, Greek, French, Italian, and Chaldaic. Chaldaic? I looked it up. It's a form of Aramaic. Right? The Hebrews, the Canaanites, and the Phoenicians spoke it at the time of Daniel the prophet, and when Jesus was alive, Chaldaic became the foundation of Arabic and Hebrew. Rabbi Rosenwasser's premise was that to understand the Bible, you have to know Hebrew. Now, the King James translation of the Bible was made in 1611, but the scientific study of Hebrew did not begin until 1753. Thus, says Rabbi Rosenwasser, much of the King James translation is inaccurate. For example, the Hebrew word bara, translated as create, actually means to set in motion. So Adam actually means any living organism containing blood. According to Rabbi Rosenwasser, the statement that we are descended from Adam could mean that we are descended from lower orders of animals. The author, Ray Ginger, tells us that Rosenwasser was with the defense team. He had brought a Hebrew copy of Genesis. He would translate the Hebrew into German, with maybe a half dozen German words for each Hebrew word. Then, according to Ginger, he would pick and choose again to turn German into English. Ginger said, the transmutations were startling. For example, Psalms, one passage, the original, he hath made a decree which shall not pass, became, according to Rabbi Rosenwasser, he hath made a law of nature which he doth not transgress. I'm no linguist or Hebrew or biblical scholar, but my take on this is, at a certain point, he who doeth the translating can maketh it say whatever he doth want. I checked in with Professor Hoffman on this, and he said, yeah, that's pretty much his view of it as well. Moral of the story, there are experts and there are experts. It's not uncommon for an expert to try to play his or her way onto a team, and I can imagine the defense lawyers thinking they were onto something. And regardless of the particular merits of Rabbi Rosenwasser's translations, they were onto something, right? That there were issues of translation, and the state had to prove that teaching evolution actually did contradict something in the Bible. What else is going on in Dayton over this weekend before Monday, day 2 of the trial? Reverend Charles Francis Potter was a Unitarian minister from New York who was associated with the defense team. He was invited to speak Sunday morning at the local First Methodist Church North. Several parishioners objected to their pastor, Reverend Howard Byrd, depicted there. Now, remember Reverend Byrd? You might remember that name. He's the modernist preacher whose teaching encouraged entrepreneur George Rapelier to buy that evolution and Christianity were not incompatible. So Potter decides not to speak, and the pastor Byrd resigns his pulpit. I have not been able to find out anything more about that, but who knows, maybe next year's OLLI course, the untold story of Pastor Howard Byrd, if I can just get it all down into 6 lectures. You have to know that if there was a Methodist church north, naturally Dayton had a Methodist church south. Who do you think was preaching at the Methodist Church South that Sunday? William Jennings Bryan. Bryan's talk, God must have had a reason for making man ignorant rather than learned. In passing on men's qualifications for heaven, God does not ask for diplomas. Bryan couples references to heaven with references to Florida, for which he was shilling for its real estate business. Let's move on to Monday, July 13th, 1925, day 2 of the trial. We are back in the courtroom where it's still hot. We're told the jurors had handheld fans with an ad for a toothpaste company, Do Your Gums Bleed? The radio engineers had to fix the hookup. Ray Ginger tells us that Judge Ralston said, my gavel will be heard round the world. Judge Ralston with the microphone. A quick introduction to the prosecution team. Tom Stewart, the name you've heard me mention already, we're told he was the Attorney General. So Attorney General, pretty impressive. Not so impressive. He was the Attorney General for this judicial district of Tennessee. And other names on the prosecution team who you'll hear me refer to. There was Ben McKenzie, Herbert Hicks, Sue Hicks, you remember him, and then there was Gordon McKenzie, the son of Ben McKenzie. After the opening prayer, General Stewart of the prosecution read the indictment to the jury. Then John Neal, one of the defense lawyers, moved to quash the indictment, to say the indictment was not legally valid. All kinds of grounds, some of it was technical stuff, but the gist of it, of course, was the Butler Act violates the Tennessee state constitution. Neal says the state constitution requires the state to, quote, cherish science and literature. In no possible way can science be taught without bringing in the doctrine of evolution. We come to the most sacred provision of the Constitution of Tennessee. No preference shall be given to any religious establishment. We don't say that the state cannot supervise and control its schools, but that control is limited by this constitutional boundary. The Butler Act, he says, also violated the article of the state constitution regarding the expression of opinion. That's a free speech argument, right? Remember the ACLU, free speech. At this point, Tom Stewart says, if he's going to go on with this, we should excuse the jury. The jury's sitting there listening to this. Darrow objects to that. Stewart asks the judge to excuse the jury. John Neal says, and this is remarkable, we got different lawyers popping up. This is not the way trials are, but this one was. John Neal says, the jury has got to be the judge of the law and the facts in this case, and this is up to the jury. Really? Not many courtroom I've ever been in. Juries rule on facts, judges rule on law. Darrow generally wanted to get as much as he could in front of a jury because he wanted to play to their hearts and minds. I'm just a little surprised to hear John Neal say that out loud. He repeats it. The jury is the judge of the law and the facts. Tom Stewart says, oh, that is all foolishness. I'm with Stewart on this. John Neal, they ought to hear anything that the court has a right to listen to. The judge says, the judge gets it right. He says, there's nothing for the jury to decide about what John Neal is talking about. The judge says, the court will be more at ease with the jury not present. Clarence Darrow says, we'll be less at ease. All right, the judge lets the jury out of the courtroom. John Neal continues, you know, this law makes it a crime to teach certain doctrines of the Bible. We're going to introduce evidence that a doctrine so indefinite that every man that reads the Bible will have a different interpretation as to exactly what that theory of creation is and how it's possible for the state of Tennessee to make a crime that which every individual would arrive at a different idea. You can't know what the offense is. You'll have just as many interpretations of the particular offense as there are individuals who read the Bible. I thought Neal was really cooking there. Then he makes some arguments that sound a little bit silly to me. He says, this law tends to say that which is an offense, if committed in the high schools, would be no offense if committed up here on the streets and highways or in the public halls of our state. I don't buy it. I mean, if I walk around stark naked in my home, that's called freedom, among other things. If I do it on Railroad Street, it's something entirely different. Now, Arthur Garfield Hayes, a minute later, adds another argument for the defense. He says, a man could not tell whether he's committing a crime. It's not clear what is meant by the word teach. Suppose during my next half hour I expound the theory of the divine creation. Have I violated the law? I presume our teacher should be prepared to teach every theory on every subject, not necessarily to teach a thing as a fact. There are many hypotheses about which the world is talking. Arthur Garfield Hayes was no fool, but this is confused, and I'm not sure what he's talking about because it begins to sound a little bit like what anti-evolutionists today call the teach the controversy approach. Just teach both sides of this. And in the final lecture, when we talk about modern-day battles, we'll talk about the controversy approach. So Arthur Garfield Hayes then makes a different kind of argument. He says, I have taken the liberty of drafting a law which it seems to me would be constitutional if this law is constitutional. And now he draws on the spirit of the great satirist Jonathan Swift in his modest proposal to help the Irish poor address their poverty by selling their children as food to the rich. That was Jonathan Swift. Arthur Garfield Hayes presents his draft statute to impose the death penalty for anyone teaching in public schools any theory that denies the biblical story that the earth is the center of the universe and instead teaches that the earth and the planets revolve around the sun. Hayes had struck a nerve. He knew the pen is mightier than the sword, or in this case, mightier than a straight-on legal argument, because in response, Attorney General Ben McKenzie, one of the state's lawyers, he seemed to get a bit hot. Ben McKenzie said, "No such act as that has ever passed through the fertile brain of a Tennessean. I don't know what they do up in his country." Up, of course, is in the north. McKenzie, if these gentlemen have any laws in the great metropolitan city of New York that conflict with the Butler Act, or in the great white city of the Northwest, he's talking about Chicago, he's talking about Darrow, that will throw any light on this, we will be glad to hear about it. Dudley Field Malone pops up. Though I do not mean to interrupt the gentleman, that means an interruption is coming, I do not consider further allusion to geographical parts of the country as particularly necessary, such as reference to New Yorkers and to citizens of Illinois. The judge, Colonel Malone, remember everybody's got a title here, Colonel Malone, you do not know General McKenzie as well as the court does. Everything he says is in a good humor. You are our guests, and we accord you the same privileges and rights and courtesies that we do any other lawyer. Malone, we appreciate the hospitality of the court and the people of Tennessee, but we are here as lawyers, not as guests. General McKenzie, we have the highest regard for these distinguished lawyers. I will admit I have no respect for their opinions that have been advanced as to the law, and we don't believe it to be the law. But as far as wanting to insult or hurt the feelings of either one of these gentlemen, that is not my intention. I have been reading from our Supreme Court opinion. I don't know whether they have any respect for that or not. This doesn't sound like pure theater to me, right? These guys are going at it. Then there's a back and forth about the police power of the state of Tennessee, that it gets to spend its money on its schools and to do in its schools as it deems fit. Sue Hicks says, the state can do what it wants. Suppose a teacher wanted to teach architecture in a school when he's been employed to teach mathematics. Suppose he's employed to teach arithmetic to the class, which the Uniform Textbook Commission has adopted. And by the way, the Uniform Textbook Commission has been established by the state. Well, by the way, teaching architecture instead of arithmetic is not the analogy. Teaching biology without evolution is like teaching architecture without the laws of physics and engineering. And of course, by the way, remember the textbook that Scopes may or may not have talked from, had been approved by the Uniform Textbook Commission and had been used in Tennessee schools for many years. These arguments of law continued on into Monday afternoon. Remember the jury that thought they had good seats to all this? They're still out of the courtroom. Tom Stewart's talking about why the Tennessee constitutional provision to cherish literature and science is not violated by the Butler Act. John Neal, I gather he admits it would be impossible to cherish science under this law. Tom Stewart, no, sir, I do not make any such admission, claiming that I do not come from a monkey. I cannot do it. Malone, we do not think you did either, General. Tom Stewart goes on arguing that the Butler Act doesn't interfere with worship or preferring one religion to another. Darrow picks up on this. He says that's the part of the Constitution that's offended by the Butler Act about preferring a religious establishment. Stewart says, in what ways? Darrow, giving preference to the Bible. Stewart, to the Bible? Darrow, yes. Why not the Koran? Stewart, might as well give it to any other book? Darrow, certainly. Stewart, and no preference shall ever be given by law to any religious establishment or mode of worship? Darrow, certainly. Tom Stewart says, the St. James Version of the Bible is the recognized one in this section of the country. Pause right there. There is so much wrong with that short sentence. Now we're talking about a particular version of the Bible as opposed to other versions of the Bible. Other versions, other words, other translations, other interpretations, right? You get the picture. He says St. James Version is the recognized one in this section of the country. Do different parts of Tennessee recognize different versions? Would the Butler Act apply differently in different counties of the state? Recognized by whom? By most people? Now we're doing this by Gallup poll. And even if so, who cares? I mean, we're going to do this by what the legislature says. If we're doing that, that's the very establishment of religion that's prohibited by the Constitution. Tom Stewart, undaunted, says the laws of the land recognize the Bible. The laws of the land recognize the law of God and Christianity as part of the common law. What laws of the land is he talking about? Now, as at other times, this begins to resemble a debate. Malone says, if the law preferred the Bible to the Koran. Stewart, it does not mention the Koran. Malone, does it not prefer the Bible to the Koran? Stewart, we are not living in a heathen country. Malone, will you answer my question? Does the law not prefer the Bible to the Koran? Stewart, we are not living in a heathen country, so how could it prefer the Bible to the Koran, right? Doesn't recognize the Koran at all. Stewart, do you say teaching the Bible in the public school is a religious matter? Malone, no, I would say to base a theory set forth in any version of the Bible to be taught in the public school is an invasion of the right of the citizen, whether exercised by the police power or by the legislature. Let me pause for a moment. Throughout these lectures, I keep wanting to make the case. Why are we doing this? Why should we be interested in this? I mean, who cares what these lawyers said in 1925? Am I just trying to make some of them sound ridiculous? Am I beating a dead horse? And to all of that, I say, please stay tuned for Lecture 6, when we talk about the legacy of the Scopes trial and later Supreme Court cases. And I will examine with you the attitude of at least one Supreme Court justice of our time about what constitutes a religious matter. Later that afternoon, Stewart is talking more about the state's power. Arthur Garfield Hayes, did the state, under the power you referred to, prescribe the book from which Scopes taught, the textbook, right? Remember, he pulled it off the shelf at Robinson's. Stewart says, there's no act on that as I understand it. Hayes, I thought you just stated that the state prescribed the school books. Did they prescribe the school books that Mr. Scopes was using? Stewart said, I said they had a right to. Hayes, did they exercise that right? Malone chimes in for Scopes. How did he get the book? I mean, was it given to him by the state? Tom Stewart, that is a matter of proof. We are prepared to show that. Do you want to put me on the witness stand? And Malone says, no, I would like to, and the transcript says, laughter in the courtroom. Oh, one lawyer putting another lawyer on the witness stand. Yeah, that is funny. Little did they know what was coming. Then there's a recess, and then Clarence Darrow spoke. I'm going to quote him at some length, because this man knew how to use language. I believe he thought he was speaking not only to the judge, sometimes also to the jury, but he was speaking to the people of Dayton, to the people of the United States, and I think he speaks to us now. A lot of exalted language came from the two playwrights and then the screenwriter, but the eloquence did not begin with them. Darrow started by saying he'd been treated with courtesy by the opposing lawyers and the community. And I shall always remember that this court is the first one that ever gave me a great title of colonel, and I hope it will stick to me when I get back north. The judge, I want you to take it back to your home with you, Colonel. Right. Now, there's no reference to laughter in the courtroom, so it's hard to know if the judge said it graciously or as a dig. Darrow, this case we have to argue is a case at law, and hard as it is for me to bring my mind to conceive it, almost impossible as it is to put my mind back into the 16th century, I'm going to argue it as if it was serious, as if it was a death struggle between two civilizations. We've been informed that the legislature has the right to prescribe the course of study in the public schools. Within reason, they no doubt have. No doubt. He goes on to say he doesn't think the legislature could eliminate math, geography, and writing to teach only religion. For instance, suppose the legislature should say, we think the religious privileges and duties of the citizens of Tennessee are much more important than education. We agree with the distinguished governor of the state. If religion must go or learning must go, why, let learning go. I don't know how much it would have to go, but let it go, and therefore we'll establish a course in the public schools of teaching, we'll establish a course in the public schools of teaching that the Christian religion as unfolded in the Bible is true, and that every other religion or more or system of ethics is false. And to carry that out, no person in the public schools shall be permitted to read or hear anything except Genesis. Would that be constitutional? If it is, the Constitution is a lie and a snare, and the people have forgot what liberty means. He quotes Bancroft. that it is all right to preserve freedom in constitutions, but when the spirit of freedom has fled from the hearts of people, then its matter is easily sacrificed under law. And so it is. Unless there is left enough of the spirit of freedom in the state of Tennessee and in the United States, there is not a single line of any constitution that can withstand bigotry and ignorance when it seeks to destroy the rights of the individual, and bigotry and ignorance are ever active. Here we find today as brazen and as bold an attempt to destroy learning as was ever made in the Middle Ages. And the only difference is we have not provided that they shall be burned at the stake, but there is time for that, Your Honor. We have to approach these things gradually. Pause for breath. This is Darrow in his greatness. It's great rhetoric. It's also serious constitutional theory. I take us back to Yale Law School professor and historian Akhil Amar. One of Professor Amar's books is entitled America's Unwritten Constitution, the Precedents and Principles We Live By. As the title suggests, his thesis is that our constitutional regimen encompasses more values and protections than our founders could possibly have articulated in the written document. So Professor Amar reminds us, separation of powers, checks and balances, the rule of law. Those phrases don't appear in the Constitution, but they're all part of what Amar calls America's working constitutional system, part of America's unwritten Constitution. So take the principle of one person, one vote. Our Constitution doesn't say so. At our nation's founding, the principle was not widely honored, and Amar says, nor did it sweep the land at any time over the next 175 years. When he wrote this particular book, The Unwritten Constitution, in 2012, he went on to say, and yet today, this unwritten rule, a rule supported by every Supreme Court justice, by both major parties, by opinion leaders of all stripes, and by an overwhelming majority of ordinary citizens, forms the bedrock of American system of government. He says our unwritten Constitution includes not only substantive content, but rules clarifying the methods for determining the meaning of this supreme law. Since the written Constitution doesn't come with a complete set of instructions about how it should be construed, we must go beyond the text to make sense of the text. Darrow was tapping into the same vein. If we strip the document of the implied spirit that motivates it, the words alone cannot save us. And as Darrow said, unless there's left enough of the spirit of freedom in the state of Tennessee and in the U.S., there's not a single line of any constitution that can withstand bigotry and ignorance. That's what Darrow's talking about. So we're constantly tested when it comes to the role of the spirit of freedom and the role of law, the rule of law and the words of the Constitution. Professor Amar gives us a terrific example of how things we know to be true are not spelled out in the Constitution. The Constitution says when the Senate convenes a trial for the impeachment of a president, the vice president, who would ordinarily preside over the Senate, shall not do so, but instead the Chief Justice shall. Why? Why should not the vice president, who ordinarily presides as the president of the Senate, why can't the vice president preside over the trial of the president? Conflict of interest, of course, right? Of course. It's an unresolvable conflict of interest to have the guy preside over a trial where, based on the outcome, he might or she might inherit the office. Now, who presides over an impeachment trial of the vice president? Professor Amar asks. And he tells us the Constitution doesn't say so, nor need it. Why? Because we all know that no person shall sit in judgment of himself, and we don't need the Constitution to tell us that. Darrow goes on. Can Your Honor tell what's given as the origin of man as shown in the Bible? Is there any human being who can tell us? There are two conflicting accounts in the first two chapters. That's the Dr. Hoffman stuff. It doesn't specify what you cannot teach, but says you cannot teach anything that conflicts with the Bible. Just imagine making it a criminal code that is so uncertain and impossible that every man must be sure that he has read everything in the Bible and not only read it, but understand it, or he might violate the criminal code. Who is the chief mogul that can tell us what the Bible means? He or they should write a book and make it plain and distinct so we would know. Let's look at it. There are in America at least 500 different sects or churches, all of which quarrel with each other and the importance and non-importance of certain things or the construction of certain passages. All along the line, they do not agree among themselves and cannot agree among themselves. They never have and probably never will. There is a great division between the Catholics and the Protestants. There is such a disagreement that my client, who is a school teacher, not only must know the subject he is teaching, but he must know everything about the Bible in reference to evolution, and he must be sure that he expresses his right, or else some fellow will come along here, more ignorant perhaps than he, and say, "You have made a bad guess, and I think you have committed a crime." This is solid stuff. But Darrow can't help himself. He didn't come to Dayton to criticize a law because it was incapable of being understood. He goes on and says, "My friend, the Attorney General, says that John Scopes knows what he is here for. Yes, I know what he is here for, because the fundamentalists are after everybody who thinks. I know why he is here. I know he's here because ignorance and bigotry are rampant, and it is a mighty strong combination, Your Honor. It makes me fearful." It's not enough in this indictment to say that John Scopes taught something contrary to the divine account written by Moses. Maybe that's not good enough. You might just as well indict a man for being no good.
Amen.
He says, if I couldn't live in peace with people I did not agree with, well, what? I couldn't live. Here's the state of Tennessee going along in its own business, teaching evolution for years, state boards handing out books on evolution, professors in colleges. Everybody's doing this, and along comes somebody who says, we've got to believe it as I believe it. It is a crime to know more than I know, and they publish a law to inhibit learning. It makes the Bible the yardstick to measure every man's intellect, to measure every man's intelligence, and to measure every man's learning. Now Darrow is really rolling. Are your mathematics good? Turn to 1 Elijah verse 2. Is your philosophy good? See 2 Samuel chapter 3. Is your astronomy good? See Genesis chapter 2, verse 7. Is your chemistry? See Deuteronomy. He's just making citations to the Bible up, but it works. And we know it works because the screenwriter to the Inherit the Wind movie took it and stole it. Darrow says, I'll tell you what's going to happen, and I do not need to be a prophet. This is a dig at Brian, who was known as the prophet from Nebraska. I don't need to be a prophet to know, and the judge says, sorry to interrupt your argument, but it's closing time. Darrow asks for 5 more minutes to continue, or he'll close in the morning. Judge says, proceed tomorrow. Whereupon Darrow kept talking. And to show this guy really had some gas left in his tank, he closed with the remarks that I began the course with. If today you can take a thing like evolution and make it a crime to teach it in the public school, tomorrow you can make it a crime to teach it in the private schools, and the next year, etc., etc. After a while, Your Honor, it's the setting of man against man and creed against creed until with flying banners and beating drums, we're marching backward to the glorious ages of the 16th century when bigots lighted faggots to burn the men who dared to bring any intelligence and enlightenment and culture to the human mind. Let me quickly note, I repeated that now, having said it last week and at the Ollie open house weeks before. You notice the phrase toward the end, when bigots lighted faggots to burn the men who dared bring any intelligence? When I first read that in the transcript, I was confused because I was only familiar with that term as a gay slur. I couldn't conceive of how it was being used here, so I looked it up. Maybe some of you already know this, but it means a bundle of sticks, twigs, or branches bound together and used as fuel or a torch, when bigots lighted faggots to burn the men who dared bring enlightenment. So I didn't include the word faggots when I made this presentation last week because I didn't want anyone to pick up on that and get distracted, at least in the opening minutes of the course. But there you have it, and that phrase does not appear in the movie. That was the end of day 2. Darrow's speech had quite an impact on some people. The author Ray Ginger said that a Dayton native came up to say to Darrow, "If I could have heard you before, I would never have spoken of you as I have in the past." Ben McKenzie of the prosecution team said, in a voice choked, truly or falsely, with emotion, "It was the greatest speech I ever heard in my life on the subject." Ray Ginger says Darrow was beginning to have an impact on the people of Dayton. He says it was not easy to remain hostile to a man as winsome and tolerant as Darrow proved to be. Let's hear a little bit from the journalist H.L. Mencken. You're generally familiar with Mencken, who was known as the great cynic. He wrote for the Baltimore Evening Sun. And his writings about the Scopes Monkey trial, I think, elevated his profile even more. The person who prepared the slides forgot to type in his name. But that's Mencken. He said, "The net effect of Clarence Darrow's great speech yesterday seems to be precisely the same as if he had balled up a rain spout in the interior of Afghanistan. The very judge on the bench, toward the end of it, began to look uneasy, but the morons in the audience, when it was over, simply hissed. During the whole time of its delivery, the old mountebank, the trickster, Brian, sat tight-lipped and unmoved. There is, of course, no reason why it should have shaken him. He has those hillbillies locked up in his pen, and he knows it. The town whisper is that the local attorney general, Stewart, is not a fundamentalist and hence has no stomach for his job. It seems not improbable. He is a man of evident education, and his argument yesterday was confined very strictly to the constitutional points, the argument of a competent and conscientious lawyer, and to me at least, very persuasive. But Stewart, after all, is a foreigner here, a Tennessean, right? He's, after all, a foreigner here, almost as much so as Darrow or Hayes or Malone. He's doing his job, and that's all. The real animus of the prosecution centers in Brian. He is the plaintiff and the prosecutor. The local lawyers are simply bottle holders for him. I have met no educated man who is not ashamed of the ridicule that has fallen upon the state, and I have met none except for John Neal, who has had the courage to speak out while it was yet time. If the state is to be saved at all, it must be saved by the courts. For one, I have little hope of relief in that direction, despite Hayes's logic and Darrow's eloquence. Constitutions in America no longer mean what they say. To mention the Bill of Rights is to be damned as a red. Mencken, too, is invoking what Professor Amar was talking about. Day 3 of the trial, Tuesday. Sorry about that. July 14th. Judge Ralston calls Reverend Stribling to open with a prayer. Darrow objects. And the judge says, look, it's my custom, I'm the judge, it's my custom to have prayers, I overrule the objection. Darrow wasn't done, he objects again. The nature of this case is where it's claimed by the state there's a conflict between science and religion. And he asked the reporters, take down the prayer you're about to hear. Mackenzie speaks up, says, this is all fine. Darrow says, I don't object to anybody praying in secret or in private, but I object to turning the courtroom into a meeting house. Tom Stewart says, the state makes no contention that there is a conflict between science and religion. It's a case involving the fact as to whether a school teacher taught a doctrine prohibited by the state. Really? There's no contention that a conflict between science and religion? Stewart then says, we think it's quite proper to open the court with prayer if the court sees fit to do so, and such an idea, extended by the agnostic counsel for the defense, is foreign to the thoughts and ideas of the people who do not know anything about infidelity and care less. Agnostic counsel for the defense. An idea that's foreign to the thoughts and ideas of people who don't know anything about infidelity. I don't even know what that part means. Arthur Garfield Hayes. May I ask to enter an exception, an objection, to the statement, agnostic counsel for the defense. Malone chimes in. Your Honor has the discretion to have a prayer or not have a prayer. Then he asks whether in other trials the judge is opened every day with a prayer. He says, because the prayers we've already heard, having been duly argumentative, that they help to increase the atmosphere of hostility to our point of view, which already exists in this community by widespread propaganda. Tom Stewart says, there's no question about what John Scopes did. So far as creating an atmosphere of hostility is concerned, I would advise Mr. Malone that this is a God-fearing country. Malone says, and it's no more God-fearing than the country that I come from. The judge says, I'm the judge, I have discretion, I overrule the objection. Whereupon Reverend Stribling goes on for in several paragraphs, including asking God to give unto us minds that are willing to be directed in the way thou wouldst have us do, and may there be in every heart and in every mind a reverence to the great creator of the world. He concludes, we ask it in the name of our blessed Redeemer, Jesus Christ. Yes, I would say the objection was overruled. The judge says he needs more time to consider the defense motion to throw out the indictment. He adjourns court until 1 o'clock. The policeman announces the court will reconvene at 2:30. Now get ready for one of the fun stories of the trial that I have a high degree of confidence you've never heard. At 2:15, Judge Ralston comes out to say that he gave strict instructions to the stenographer, the court reporter taking this all down, that Judge Ralston's opinion on this pending motion to throw out the indictment was not to be released to any person. If any member of the press has any intimation as to what my opinion is, no person knows except myself and the stenographer. And if anybody sends it out before I begin to read it, I will deal with them for contempt of court. At 3:45, court is called to order. Arthur Garfield Hayes now presents a petition. And we're going to get a different kind of entertainment. Hold the thought about Judge Ralston's concern about the press and his opinion on throwing out the indictment. Arthur Garfield Hayes presents a petition from representatives of religious organizations, churches, and synagogues that if you continue your custom of opening the daily sessions of the court of Ray County with prayer, and Tom Stewart jumps up and says, Your Honor has ruled. And Arthur Garfield Hayes says, I insist on making my motion. Stewart says, I am making my objection to the court. Will you please keep your mouth shut? Judge, I will hear the motion. Stewart, I object to it with all the vehemence of my nature. Arthur Garfield Hayes reads the petition. Piece of it says, there are many to whom the prayers of the fundamentalists are not spiritually uplifting and are occasionally offensive. Seems to us only just and right that we should occasionally hear a prayer which requires no mental reservations on our part and in which we can conscientiously participate. That's what the petition asks for. Alternate between fundamentalists and non-fundamentalist preachers. Judge Ralston says, I shall refer the petition to the Pastors Association of the town. The court reporter puts in the transcript, laughter and loud applause and rapping for order by the policemen. The question is, why were they laughing? Why were they applauding? Were they laughing at the judge? Were they laughing at Hayes and the way the judge was dismissive? Ray Ginger says the press first thought the judge was making a joke. Then they realized this was his way of trying to be impartial. So the judge says, I'll ask the Pastors Association to name the man who does the daily prayer. I'll stay out of the pastor selection process. This is now what passes as the separation of church and state in this courtroom. John Neal, Your Honor knows that the men Your Honor refers this motion to are not among the class of men who signed the petition. Right? The Pastors Association can be the same people who've been delivering the prayers. The judge says, I see by the press one minister has resigned his post recently because Dr. Potter, that was Reverend Byrd, remember he resigned, because Dr. Potter was not allowed to preach in his church. I take it he's in sympathy with Dr. Potter and his doctrine. The others are perhaps fundamentalists, I don't know. Perhaps fundamentalists? We know who signed this petition, a Congregationalist, 2 Unitarians, and a Reformed Jew. Perhaps fundamentalists? I don't know whether the judge was just ignorant or having some fun with us. Who signed the petition? Reverend Charles Potter, the Unitarian. Reverend Fred Hagan, First Congregational Church in Huntington, West Virginia. A Reverend Welch from the Knoxville Unitarian Church. Couldn't find anything about him. Then, Rabbi Jerome Mark of Temple Beth El in Knoxville, Tennessee. You know by now, I couldn't help myself. Who is this rabbi who showed up on a petition in the Scopes case? How could I find out who could tell me about Rabbi Mark? I played a quick game of Jewish geography. I Googled Temple Beth El in Knoxville. It still exists. Who's the rabbi? Rabbi Aaron Boxt, the brother of a good friend of mine. I email Rabbi Bakst. I tell him what I'm up to. Can anybody there tell me about Rabbi Mark? Are there any stories to tell? A few hours later, I was connected to the grandson and the granddaughter of Rabbi Jerome Mark. This was just too easy. Jerome Mark was ordained as a Reform rabbi in Cincinnati on June 1, 1918. We're told from reports of the Reform movement that he traveled in the South and the Southwest, attending to various small congregations and groups of Jews in places like Forest City, Arkansas, Marianna, Arkansas, Helena, Arkansas. All right, so Congregation Bethel of Knoxville reports that Rabbi Mark became their first resident rabbi in 1922 and that he left in 1926 to take a pulpit in Selma, Alabama. Why did Rabbi Mark leave? Well, what happened between 1922 and 1926? That's right, Dayton 1925 happened. Let me share with you some of what his granddaughter, Roz Schanzer, reported to me. She said, my grandfather was a rabbi in Knoxville 2 different times, and the trial in 1925 occurred during his first posting there when he was 34 years old. He had wanted to speak to his congregation about the trial, but the board of directors at Temple Bethel absolutely forbade it because they were afraid his sermon would infuriate the Ku Klux Klan and other anti-Jewish elements in Knoxville. He argued that the board didn't even know what he planned to say, but they didn't care, so he quit. And he went to Selma, Alabama, and then later on became the first Reform rabbi in Sydney, Australia. Roz sent me an 8-page letter typed by her grandfather. It focused largely on the lawyers and the judge and the hubbub surrounding the trial. The letter was dated April 9, 1959, 34 years after the trial, and it's entitled Reminiscences of the Scopes Trial. Rabbi Mark said he attended the trial as an interested onlooker. He got to Dayton. He joined the crowd in front of Robinson's drugstore, and there he was met by the lawyer John Neal. Then Arthur Garfield Hayes came over and said to Rabbi Mark, being the only Jew on the counsel for the defense, I want to meet the rabbi. Rabbi Mark said in his letter that he had met Darrow, who, quote, impressed me as a man of sincerity, although he was fully conscious of his role in the drama and was self-centered enough to make the most of it. He said his impression of Brian was a great orator, a man with capacity for thinking, but circumscribed by past experiences as a politician and by his very sincere but narrow understanding of the Bible and religion. He said Tom Stewart was uninspiring. No wonder that when he became U.S. Senator later, the Tennessee newspapers called him Me Too Stewart. What about Judge Ralston? Rabbi Mark said, very small mental capacity or ability. We'll hear a bit more about from Rabbi Mark next week when his reminiscences provide us some color commentary on one of the most entertaining episodes in the courtroom that I've planted the seed for already. Roz Schanzer also sent me a 1-page letter from a guy named Ben Winnick. This was another Knoxville Jewish attendee of the trial. So Ben Winnick wrote to a friend of his at the time, I never saw such a prejudiced crowd of people as Dayton has. They are 95% anti-evolution, and Brian, as he sits there, is their idol. The trial looks like a Spanish Inquisition in that everything or anything that does not stick to their literal translation of the Bible is looked upon as heresy, and the defense attorneys and their sympathizers are looked upon as infidels. I certainly am glad I came down, for from the looks of things, this trial is going down in history. In fact, it looks like a fight against religious bigotry. Rabbi Mark is here, and I believe he will deliver a prayer in court Friday morning. Well, Roz also wrote to me that somewhere there's a third, potentially more important letter in which her grandfather explained his role working with Clarence Darrow, but none of us have ever been able to find it. Oh, Roz. She continues, my mom and my grandparents always told us that Darrow originally sent a telegram to the Hebrew Union College, the Reform Rabbinic Seminary, asking about finding a biblical scholar who could lend him a hand. And they telegraphed back to say there was already an outstanding authority on the scene named Rabbi Jerome Mark. As you and I mentioned earlier, me and Roz, my grandfather was also supposed to give an opening prayer one day during the trial. As it turned out, he never got the chance because he was asked to do it on a Friday, but he had to speak to his own congregation in Knoxville that evening instead. all the times that services get in the way of doing the cool stuff you want to do. That's me talking. One last word about Rabbi Mark, under the heading of How Messy History Can Be. Rabbi Mark died in 1967. His granddaughter sent me 2 newspaper obituaries and a 1963 article about his return to Knoxville after he retired from the rabbinate. All 3 articles refer to him as an expert witness at the trial, which he was not. One said, to his surprise, he was called as an expert witness to give an interpretation of the Hebrew Scriptures. Well, that would have been to his surprise and to ours, because he wasn't. Neither Roz in her research nor I in mine have found any reference to Rabbi Mark being an expert or an interpreter of anything. Back to legal business, kind of. Remember, the judge said he had under consideration a defense motion to dismiss the case. He now said in open court that he has a lengthy opinion that he has dictated, that he gave it to a court reporter in secret. He said, I have not intimated to any living soul what my opinion was, except to the stenographer. I am now informed that the newspapers in the large cities are being sold, which undertake to state what my opinion is. Any person that sent out such information, I will deal with them as the law directs. And the judge says, because of this, he's going to hold off announcing his decision until the next morning. He wants to meet with all the members of the press. Dudley Field Malone, can we quickly dispose of the motion? Witnesses are on their way. Judge, Colonel Malone, we cannot go any further until I decide these questions that are before me, and I think I have announced satisfactory reasons for not doing so this afternoon. I regret very much to have this delay. Of course, I don't mind so much personally because I am absolutely exhausted in the preparation of this opinion. What was he writing? Brown versus Board of Education, right? Now the judge meets with the press. I have information, gentlemen, that the newspapers are being sold in the eastern cities now, which undertake to state what my action was on the motion. He reads a wire. The St. Louis Star, out final, carrying story. Law has been held constitutional by judge. The judge appoints a committee of 5 newspapermen to investigate how this happened. That was it for Tuesday, July 14th, the 3rd day of the trial. We've had 3 days of trial, 3 days taken up almost entirely with lawyers arguing. That night, the committee of 5 reporters met to figure out how one of their colleagues had written the article about the decision that had not yet been announced, the article that infuriated Judge Ralston. What did they figure out? How did they do it? Next week, we will resume with day 4 of the trial.
What was Ralston's background? Was he a practicing attorney before he became judge? Did he have any legal training?
I think the answer is, and I'll go back and double check myself, but yeah, he'd been a lawyer. But remember, I mean, and I have practiced law in large law firms, small law firms, worked with all kinds of lawyers, so I want to be very clear. I mean, no disparagement by this, but the kind of practice that he would have had in Dayton, Tennessee, compared to the kinds of issues that he was asked to address here. So 2 different worlds. 2 different worlds. Yeah?
You mentioned that the jury was all male. Was that because of state regulations or?
Sure, thank you for asking that. And as I read some of the vocabulary from this, I feel impelled to point out that, of course, this is the vocabulary of the time. And when it comes to, my joke about Sue Hicks, imagine the leading lawyer in Dayton was a woman, don't be ridiculous. That wasn't going to happen. And the jury pool was all male as well. I mean, I don't know whether that was a matter of, was it in the state constitution? Was there a formal law about that? That I don't know, but we know it was entirely male. While I have you, it has occurred to me, when I gave you the list of resources last week, making clear that there's no required reading for the course, but I think I should urge you to do one thing. In lecture number 5, the next to last lecture, the entire day is devoted to the phenomenon of Inherit the Wind. How did the play come to be written? How did it come to be produced? And that's a terrific story. And then ultimately, how did it get to Broadway? How was the movie made? And then how is the fictionalized version the same as or different from what I will have described for you by that point? I strongly encourage you, if you have not watched it recently, to go back and watch the movie Inherit the Wind. It's a terrific movie, and if you go back and watch it, it will help you appreciate a little better some of the things I'll be talking about. And I put in the resources where you can get it. I don't want to get it wrong, but I think like it may be available either to rent it off of Netflix or Amazon Prime. I actually bought a copy for myself that I found on Amazon, got the DVD of it. But you do want to make sure that if you're watching it, the version we'll be talking mostly about is the one with Spencer Tracy, Frederick March, and Gene Kelly. Because there were other versions made for television. There was at least one other movie version, but the Spencer Tracy version is the one that I'll be addressing. Anything else before we leave?
In your presentation, one of the presentations of Darrow's remarks, he uses the terms bigotry and ignorance, talking about the people who passed this law and who were defending it, and that on the other side is knowledge and progress and everything else. I don't know if this is from the transcript. In Inherit the Wind, there's that line about abandoning the pretty poetry of Genesis, which Brian flips out about.
Right.
The idea that either you're ignorant and bigoted or you're in favor of progress, as a strategy, as opposed to the thought of, am I going to offend the jury, because you're saying you people who might believe in this are bigoted and ignorant. How did he get away with that? Because it always intrigued me.
I'm remembering that I've been asked to repeat the questions, so this is being recorded. To capture it, in Inherit the Wind, Darrow at one point turns in the middle of the trial and starts addressing the jury, which of course doesn't happen, and says, now we have flight. So, but now the clouds will smell of gasoline, and he concludes that segment by saying, to appreciate all of this progress, we must abandon our faith in the pretty poetry of Genesis. And William Jennings, Matthew Harrison Brady, the William Jennings Bryan character, it responds emphatically, we must not abandon our faith. So there are threads of that in the real trial, some of which you heard. And in fact, it's one of the reasons I made a point of quoting Darrow's statement about, we know why the fundamentalists are here, and he aligns that ignorance of theirs with bigotry. And that was exactly what the ACLU had in mind when they were saying Darrow will be too confrontational about this, because they wanted to go the free speech route rather than the pitting it as a religion versus science issue. This is an even richer topic than you might have anticipated by your question, though, because there's a temptation, certainly fostered by the movie, to see this as all the people with goodness in their hearts were on one side of this question and everybody else was ignorant and bigoted. It's more nuanced than that. For one thing, Bryan himself politically was a progressive guy, right? Women's suffrage, workers' rights. It wasn't an accident that he and Darrow made common cause on political issues. One of the motivations for Bryan, we're told, is his fierce opposition to eugenics, right? Whereas H.L. Mencken, a self-appointed spokesperson for the Scopes team, he was a eugenicist. He was a notorious anti-Semite. So you say, well, how do you square different people who are on different sides of those issues winding up on one side or the other? And the answer is, this is complicated, that different things motivated different people to take their positions on the evolution issue, and it did not necessarily translate into, if you were anti-teaching of evolution, therefore you were a bigot in every way that we can imagine. It doesn't work that simply. Last question.
I wasn't here last week. The resource list, is that everywhere?
It's available on the, I am reliably informed, it's available on the OLLI website with this course. With that, court is adjourned. See you next week. Thank you, everybody.
At OLLI, the Osher Lifelong Learning Institute at Berkshire Community College, enjoy learning simply for the love of it. Educational partners Williams College, BCC, Bard College at Simon's Rock, and MCLA provide some of our outstanding faculty. Take a class in the arts, history, literature, and so much more. Contact OLLI today. Meet new friends. Keep your curiosity alive.